All right, now we'll move forward with the next session on litigation strategies, where we'll discuss mediation and ADR as potential pre-litigation or mid-litigation options for dispute resolution. As a moderator, we have Mr. John Lowe, Arbitrator and Mediator, Lowe Arbitration, France. And as our panelists, we have Ayman Al-Ashry, Senior Legal Consultant, Hamdan Al-Shamsi Lawyers and Legal Consultants LLC UAE, Mr. John Lowe, Arbitrator and Mediator, Lowe Arbitration, France, Mr. Varun K. Chopra, Managing Partner, VKC Law India, Jeremie Fierville, Partner, Signature Litigation, France, and Palash Gupta, Partner, Jeremie Merchant, India.
I'll sit here and take a spot.
Good. How do you want? Like this?
This is perfect. Okay, welcome everybody. We're going to, right before lunch, we're going to have what I hope is a very interesting and interactive session. We have a very distinguished panel, at least I think so, and it's going to be up to you to judge. What we're going to do is we're going to talk about mediation as a method for resolving disputes, and we're also going to talk about mediation, whether it's best at the beginning of a dispute or whether it's best somewhat midway between the dispute. And to do this, we need to start, I think we're going to get started. We have a number of questions, so I'm going to ask the panelists to be somewhat succinct and short in your responses because we have a lot of ground to cover, and I hope we can do that. So Palash, if we can get started, because generally, if we're talking about mediation, we generally need an alternative dispute resolution clause. Generally speaking, these will be multi-tiered clause. So can you get us started with how these are structured and how they work?
Absolutely. Well, the beauty of the MTDR, or the multi-tiered dispute resolution clause that John mentioned, is that it's a creature of contract. So as contracting parties, you have the full freedom to structure the clause in whichever way you want, subject to negotiation, correct? And there are a couple of ways of structuring the MTDRs. One, you could have a simple mediation clause, which basically requires parties to attempt to resolve disputes through mediation before they go to court. The more complicated clause, but sometimes the more effective one, is what I call the cascading clause, by which you go through a negotiation, mediation, arbitration, or a negotiation, mediation, litigation process. And you'd structure this in 3 or 4 succinct steps. The first step would be to require the parties to try and resolve disputes arising out of or in connection with the contract through negotiation. I'm a fan of specifying a time limit and specifying the parties, either the board members or the CEO or a specific SPOC, point of contact, of the parties to start and conclude the negotiation. The second step, if negotiation fails within the specified time limit, is to set up a mediation clause. And the clause effectively says that if parties are unable to negotiate, to resolve their disputes through negotiation within the X number of days, say 30 days, they commit to trying to resolve disputes through mediation in a specific location, say Singapore, at the Singapore International Mediation Center, in accordance with the rules in force at the time the dispute arises. Specify the platform, specify the rules, specify the administering institution, and you'll save yourself a lot of grief and time. And ideally, specify the way in which the mediator is to be appointed. And I think Jeremie will go more into this in detail, but like with any good arbitration clause, the more specific you are, the less is the potential for delay at the beginning of proceedings. And the last step of the MTDR would be to say that if mediation fails, or if one of the parties refuses to participate, then and only then, at the conclusion of the mediation, should parties try and resolve dispute through arbitration or litigation, as the case may be. With one little caveat. The caveat is that if you need urgent interim relief and you're able to demonstrate it, then rather than lose time through mediation, a demonstrable need for injunction, you slip that in as a caveat. But other than that, put parties through a mediation, let's get them to the table, have a talk, understand the strength or the weakness of your case, and it is only at the conclusion of the mediation process that you are allowed to go to litigate or to arbitrate your dispute. That's typically how a cascading multi-tiered dispute resolution clause is structured.
Thank you, Palash. And thank you for that introduction to mediation. You've discussed mediation as a contractual arrangement between the parties. I think I'll ask Ayman and Chopra to say a few words about mediation as mandated by courts, because both of them are active in jurisdictions where the court systems are becoming much more active in promoting mediation. And I think Jeremie can say something about it in France. I'll say a little word about it in Italy. But courts right now, even if the parties don't have a mediation clause, are becoming more aggressive in pushing mediation. So can we get you started?
Yeah, sure. Thank you, John, for that. As a litigator, of course, I will take you through the mediation process in the UAE. To be honest, that the UAE has become one of the most friendly environment for mediation and ADR. Recently, there is a lot of laws and regulations organizing the process of the mediation in the UAE, as we consider it a pre-litigation process or pre-arbitration process. So if we say that from the perspective that the UAE the UAE community consists of people from different backgrounds, from different legal systems. So mediation is actually part of the legal system which uniting those backgrounds in order to settle the dispute or in order to find a solution or resolve the problematic issue that they have. So if we saying the mediation process has become mandatory in some certain cases in the UAE, I have to mention that there is a recent law have been issued in the UAE, Federal Law number 40 of the year 2023 concerning the mediation and conciliation in the UAE. For that law, the law is actually mandating the parties to go for the mediation process prior to filing the litigation cases. This law is actually concerning the federal courts, such as the Charger courts, Fujairah, Al-Quwain courts, that if the claim amount for the commercial dispute is less than 5 million, so the parties has to file the case before the conciliation circuit or the conciliation tribunal in order to have a judgment or to finalize the process before referring the case to the bench trial or something. So this process, we can consider it as a mandatory mediation before filing the litigation case in the normal court. Of course, there is a lot of conditions and there is a lot of aspects for that and requirements for the person who is dealing with the mediation. Sometimes it should be chosen by the parties themselves. Sometimes it should be chosen by the court itself, and also it would be fees for the mediator to be paid from the parties before leading to a settlement, final settlement, or final resolution in the case before filing in the normal bench trial court. Another form of mediation in the UAE, and to be honest, I should start with the legal notice. As a litigator, even before going to the courts or going for mediation center or arbitration center or something, we have, in some cases, we have to put the respondent in a defaulted situation, like to tell them that you are defaulted, you didn't pay that much amount of money, or you breached that contract, and that's why there is a dispute should be filed in the horizon. And I consider this process of filing the legal notice is the initiation of the mediation process, because I'm giving them the opportunity to settle the matter before filing the case in the court. So certain days must be lapsed after serving the legal notice, and then we consider those days as the mediation grace period before I file the case or before the party need to file a case. So after that, we come to another form of the mandatory mediation in the court, which is, for example, for the labor cases. In the UAE, according to the law, the employment law, the parties has to file the complaint before a specific tribunal in the Ministry of Human Resources, which we call it MOHRI, in order to finalize and resolve the labor issue before we file the case in the main court. If the parties did not follow that process, then the case would be lost or the case would not be heard at from the beginning, because it's a mandatory step to be done as a mandatory mediation, if we can call it that name.
Okay, thank you for this introduction to the UAE. Chopra, can you say a few words about India right now and how things are working there?
Okay, thank you, John, so much. So India is also very similar to the UAE, but the concept of mediation in India actually arose in 1999 when our Civil Procedural Code was amended, and it brought in a particular section where it mandated parties to had the party autonomy to go into mediation. Pursuant to that, there was a judgment of the Honorable Supreme Court in 2005, which mandated all the high courts in India to have an annexed mediation center. The first annexed mediation center in India opened in Chennai, that is the Madras High Court, and thereafter it came into Delhi in 2006 as Samadhan. What is the mandate of these mediation center? Similar to UAE, there is a Corporate Commercial Act in India, Code Commercial Act in India in 2015, which has pre-litigation mediation is mandatory. You have to go into mediation on corporate disputes. Thereafter, once that report is come, and thereafter you go to the court. Of course, there is a monetary limit involved in that as well. Now, the latest and the most beautiful advancement, I would say, which has come in India is the Mediation Act 2023, which has just come in, and it has been effective from 9th of October 2023. It mandates and enlists several aspects of mediation, including institutionalizing the mediation centers. And also, it has concepts of pre-litigation mediation and various things. So I believe that the concept of mediation is developing and has a very, very bright future. And so I would like to add one thing. I wrote it down, so it's for all. An ounce of mediation is worth a pound of arbitration and a ton of litigation. Right? So we should always remember this. That's why mediation is the first step. and we should all focus on that. So that's the way India is going at the moment.
Thank you, Chopra. Before we start going into techniques of mediation and how successful mediation is, I'd like to ask Jeremie. Jeremie has a lot of experience working with multinational companies, some of which are actually big, very large promoters of mediation, and some of which have less favorable impressions of mediation. So, Jeremie, could you speak about what your clients think about mediation?
Yeah, sure. Thank you, John. So, just about France, that's the same as we've seen in your regions. There is a push, clearly strong push in favor of mediation from the business and from the government. From the business, because it's clearly the most business-friendly way of solving disputes, and from the government with different laws, also because it's a way to manage the different cases and the delays in the proceedings, especially since COVID-19. So both government and companies are pushing in favor of mediation. Now, for the global companies, I've got experience from my clients, but also from companies and general counsels with whom I teach at university. So they are the general counsels at French groups Veolia, Accor, Hotels, and Renault. And they have different approaches, all of them, to mediation. And basically there is a mix. I would say there are two approaches. One is to say that it's on a case-by-case basis. And this is a way to say, a polite way to say that they are quite reluctant. And in fact, some large groups are quite reluctant because they have had some bad experiences with some mediations that failed and in important cases with top management involved. I've got specific examples of that. But other companies are really, really enthusiastic, and we're seeing this approach growing. Why? Because of obvious reasons. They put systematic mediation clauses in all their contracts because they decrease the legal costs overall. When you've got hundreds of cases that you need to litigate or arbitrate in a year, if you've got mediation clauses to start with, at the systematic level, you will decrease the overall budget of dispute resolution of the firm, the company. And then you will increase the speed in the dispute resolution. So this is also good for business. And finally, you will increase the experience internally by the lawyers about mediation. And this is a way to gain experience, expertise, efficiency to solve the disputes internally by the multiplication of cases and mediations. I will just finish with one word. These kind of companies are really willing to train their lawyers. So I've been, for instance, just to give you one example, I've been asked to train more than 100 lawyers of the Safran Group, which is defense and aeronautic company, just for them to know exactly what mediation is about, how to trigger mediation, and how to manage mediation. So we're seeing this approach really rising.
Thank you, Jeremie. And I think your final point was actually a very important point to properly assist your clients with a mediation. You need to know how it works. Because a counsel does not always act the same way in a mediation that they do in a arbitration or a litigation. And I think this is a good way now to start talking about what are the components of a successful mediation and how does a mediation tend to work or not work. And Palash, can you get us started here?
Yeah. I focus a lot of my practice in Southeast Asia, and the one thing that I've noticed is that different countries have different approaches to mediation, and this directly affects the outcome. I do a lot of mediation work in Singapore, and the Singapore International Mediation Center, the SIMC, has clear rules a number of very well-trained mediators, and a manageable caseload. So when parties come to the SIMC for mediation, the process tends to be effective. Parties sit across the table. There's a little cooling off period where the initial angst of going to litigation is cut down because you're now actually sitting and trying to negotiate and talk things through. And sometimes a skilled mediator can actually help a party to understand the strengths and the relative weaknesses of their case. And at the end of a good mediation process, where parties have not only had a chance to sit down and talk to each other, but have also had a chance to assess the strengths and the weaknesses of the case, I've often seen the appetite for litigation, expensive, time-consuming litigation, come down. And I think in Singapore, we've managed this process quite effectively. There are other jurisdictions, though, when this doesn't work. I've got a decent-sized practice in the Philippines, and nobody in Manila believes that mediation actually helps you resolve a dispute. And that's because the process which has been put into place in the Philippines is very different from that in Singapore. The mediators in the Philippines are very well-meaning, but A, they have a very large caseload, and B, they don't often have a structure behind them. So when parties start doing mediation in the Philippines, the mediation goes nowhere quickly. And very often, all too often, I see the mediator just gives up because they don't have the time, the resources, or the energy to handle their caseload. So a few sessions into the mediation, the mediator has given up and has largely left the parties to try and negotiate the process out. And it just doesn't work. To the point in which in-house counsel and lawyers in the Philippines today believe that mediation is just a waste of time and energy and effort, and they'd rather go into litigation. So to me, coming back to what John said, the process starts through a skilled mediator with a manageable caseload and clear rules where parties can sit down and actually talk to each other and try and resolve their disputes. But the best mediators I've seen are the ones that help parties try and understand the strengths and the weaknesses of their case, because you can cut a litigation short by understanding where you stand.
Maybe you want to say something about the mediators and how they work in the UAE.
Yeah, I want to say something about and also comment on a very important topic, or matter that it's actually depends on it's related about the confidence in the mediation process and how the parties believe in the enforceability of the mediation decision or resolutions. And for that, I see the UAE recently has made a significant change in the regulations of the mediation that back to the federal law of number 40 of the year 2023, there is a certain article stipulating that in the decisions or the resolutions of the mediator might become as an execution deed, or it would be enforceable as if the parties agreed on a specific settlement before the mediation forum or before the mediation circuit, then they can easily enforce that settlement by the court itself. So the mediation resolution has become like an award or like a judgment. So I believe that this has given the mediation process the enforceability and the gravity that makes the parties become confident in it more than before. Yeah.
Okay, thank you, Ayman. Chopra, mediation has really just started to take off in India. How is it working? Is it successful? And how good are the mediators that you've been associated with? That's a lot of questions in 30 seconds.
I'll try to summarize them. So thank you so much, John. So I happen to be a trained mediator by the Supreme Court. And see, now the Mediation Act has kicked in. There are two aspects to it. One is a pre-litigation stage. The other is a mid-stream litigation stage where mediators can be appointed. Now one has to keep in mind who is a mediator. That is the principal question in mind. A mediator has to be a neutral person, should have appropriate qualification, should be accredited if possible through a council, which is going to happen in India. Second thing, last thing and most important thing is there should not be any conflict of interest. That is very, very important. And the new Act of 2023 in India mandates that the mediator has to give a disclosure of conflict of interest, which is very similar to our Arbitration Act as well. So that conflict of interest, however, it is subject to the parties, that parties can waive off that disclosure as well. Now, what is happening in India, since mediation is going to be institutionalized, there are councils which have training centers which train these mediators, and these mediators can be appointed through those councils. The only glitch or the impediment which the mediators and the parties, or even in fact the mediators see here, is the fee component. The fee component of the mediators, which are controlled by the government agencies, is not that high. So that is where the mediators also lack their interest, which has to be covered in some way or the other in order to come to a good conclusion, so that the parties are at a win-win situation sometimes, or at 60-40 situation sometimes. So that aspect has to be looped in. Then there could be, in terms of midstream mediators, it is court appointed. Usually the court will have impaneled list of mediators, like Supreme Court. I am practicing in the Supreme Court. I am part of the list of the mediators which are impaneled. So court during during a midstream litigation, maybe a corporate commercial litigation, a property dispute, etc., court can definitely pull a name out of the mediators and appoint it. And in fact, the courts also designate the fee, or also tell the parties that they have to bear the fees of the mediator. So that is how mediation is going along in India at the moment.
I will just add one point of view as a mediator myself. I generally like getting paid up front so that I don't have to worry about anything at the end of the mediation. And if necessary, I will actually refund money, but I do try to get all the money paid up front. Jeremie, let me ask you, you had some good stories about how you identify, or how you have seen identified mediators and how they are chosen, because frankly in a mediation, the mediator is key.
Yeah, this is clearly a key factor of success. So the qualities you talked about, it's for me to inspire trust. That means obviously to be neutral, independent, and also experienced. So you have either technical experience in the field or experience as a mediator, which I think is the most important to solve the disputes. And you need to inspire trust, but also authority, because you're a third party and you need to have some kind of authority on the parties by your experience. And so now, how to select a mediator? And that's a tricky point, because obviously if you come to the other party with the name of a mediator, he will immediately consider that this is not someone neutral, independent. So you most of the time rely on a mediation center, and we've got excellent mediation centers in France for domestic or international mediations. But if you do that, you know the case better than anyone, and maybe the mediation center will not be able to identify the proper party which will inspire trust from the parties. So what we've done, and I think that's the better way to do it, is to have an agreement with the other party, to ask one or several mediation centers to suggest a mediator, then to interview them. So each party interviews separately one mediator, and to discuss about it. And if you do not agree, if you think that's not the appropriate person, and we had the case where we, with the other party, we agreed that the first person was not the appropriate one, we asked the mediation center for a second person. We interviewed, and in the end, we agreed that we discussed, and we agreed that one of these two persons was the one that we wanted. If we had failed to go through that process, obviously we would have referred the choice to the mediation center in the end. But that was a way to have a first agreement, so the first step toward an agreement and a settlement with the other party is to agree on the process. So you do not discuss the case and what's about the dispute. You discuss about the process, and that's I thought it was a good way to have a first agreement, first success before starting even the mediation.
Yeah, you are actually already starting the negotiation without starting the negotiation.
Exactly.
Okay.
Yeah.
Go ahead, Amma.
Yeah, thank you, Jeremy, for that. And I think you have make me thought about something alarming as a litigator concerning the agreement before the mediation. I believe, deeply believe, that a well-drafted dispute resolution clause or mediation clause is actually helping the parties a lot to determine the process in case that they need, in case there is a dispute and they need mediation to be happen. Because without a well-drafted dispute resolution clause or mediation clause, they will get lost. I see a lot of examples and a lot of cases in UAE here that the dispute resolution clause is not drafted well, and parties are confused where to go and which forum for mediation to go and which forum is actually having the jurisdiction to hear their dispute. So I think this is a first step for parties, for lawyers, to advise their clients about how to have a very well-drafted dispute resolution clause before going for mediation. Something, yeah.
And go ahead, Palash.
You know, they always say that in a corporate transaction, the dispute resolution clause is the midnight clause. You've got to get your agreement done by the end of the day, and the last thing that the lawyers sit and do is draft the dispute resolution clause. But the point that he made was absolutely spot on. Your dispute resolution clause can save you a lot of time, energy, and cost if it's well drafted. In all my arbitration matters, I teach at a law school in the Philippines, and I keep telling my students, make sure you specify the governing law, the seat of the arbitration, yes, the institution that's going to administer the arbitration, the number of arbitrators, and the process by which the arbitrator is to be appointed. And it's the same for mediation. Because at the end of the day, it's always one party that's in a hurry to push the dispute resolution through, that's the claimant. And it's the other party, the respondent, that's actually often seeking to slow things down and make it costly and less time efficient for the claimant. The advantage of having a well-drafted dispute resolution clause, midnight or no midnight, is that later on you save yourself a lot of grief and a lot of money by just having your components in place. Pick the platform, pick the rules, and pick the process for appointing your arbitrator or mediator. Life just works out.
Okay. One of the subjects we've been asked to address in this session is mediation midstream, and it's actually very hard to draft a mediation clause that says, well, we're not going to mediate right at the beginning of the dispute, but 2 or 3 months into the dispute, after we realize that it's going to cost a lot of money and take us a lot of management time, and maybe the other side's positions weren't as stupid as we thought, that's when we really want to mediate. I'm going to ask my panelists, starting with Chopra, to talk about this, but my own experience is, if you've started a mediation, and frankly, oftentimes they don't work, especially at the beginning of the dispute, the fact that you've started it at least lets the parties know that it's an option maybe to be used at some time in the future. And Chopra, perhaps you can continue with this.
See, thank you so much. See, before mediation, we have to understand a few concepts. First is to understand the client's goal and the suitability of that case, whether it is fit for mediation or not during that dispute period. The second would be we have to initially only develop a strategy how you want to mediate this problem. And now during the mediation, what one has to understand how you can take this forward is you need to have an adaptive, collaborative and flexible approach during the mediation. Then utilize effective communication skills between the parties so that the mediation can reach to a conclusion. And lastly is that we have to be focused and patient, which is very critical for lawyers, those who are with the mediator. That is the key point. If you are focused and patient with the mediation, it should go through. Back to you.
Okay, thank you. Jeremie, I think it's time to get into discussing some case studies, and you have a couple of good case studies about mediation midway or even further along in a dispute?
Yeah, midstream mediation. And maybe two examples to share with you. The first one is a mediation ordered by the French Supreme Court, which is a new thing that was allowed 3 years ago. And I was a counsel for the first case that was referred to mediation by the French Supreme Court, which is in itself something odd, because the French Supreme Court is not supposed to have an assessment on facts. So they should not even determine whether there is an interest for mediation in a particular case. But they did in that case. They had the power to do that for a couple of months and decided, in my case, a shareholders' disputes, to refer the case to the mediation. And obviously, if you are in front of the French Supreme Court, it's because you have had a long and fierceful battle before first instance, Court of Appeal, and you are ready to go a long way. But also the party were exhausted. And in fact, for years, they had not been in a position to be around the table to discuss the case, only through litigation with lawyers. So this was an excellent opportunity to share their interest at that point in time, after years of disputes. And it was not a success at the end of the mediation, but it was a success a couple of months later, which often happened with mediation. Because this opportunity, which was triggered by the Supreme Court to discuss the case, allowed the party to reflect on their positions, interests, and finally to say, okay, we are ready to compromise and reach a settlement. And in that period of time, which is very important, the proceedings before the French Supreme Court were stayed. So the process was stayed and could have resumed and lasted for even longer due to the mediation. So that's something, a tool which needs to be thought after well by the parties and the French Supreme Court. The second case is very interesting. This is a famous public case between Areva, so the French nuclear group, and Finland about so that's a construction arbitration dispute, multi-billion disputes in relation to the construction of next generation nuclear power plant in Finland. The construction was delayed and there was lots of costs related to that. So there was a claim by the company in Finland against Areva. This was raised to arbitration, so with immense costs in terms of lawyers, arbitral tribunal, experts, witnesses, etc., etc. So that were dozens of millions spent on legal costs. And finally, at some point, several years after the arbitration started, the parties, with the decision was made by Areva to suggest this to all the parties to start a mediation. And it was a success. It was finally a settlement for €500 million. It was a success because the mediator was excellent, and they had the ability to have an internal new views on the matter inside Areva, then convince their other company, which was Siemens, in the case, in the matter, and then go and convince the Finland counterparty to go for this arbitration, so for this mediation. And this was probably a very long mediation for a bit less than 1 year, but in the end, a settlement agreement that was, if they had continued with the arbitration, it would have lasted for many, many years. And just obviously, they were still continuing to build the power plant alongside the disputes. So they were very relieved to reach an agreement, turn that page, and go to another story. And finally, the power plant started 2 years ago.
Thank you, Jeremie. Those were excellent examples. I think my colleagues have something to say without any questions, so go ahead, Palas.
Thank you, John. Our firm is currently involved in a case in the Mumbai High Court, which has been subject to or sent to mid-litigation mediation. It's a trademark infringement suit. Our client filed against 5 parties, 5 defendants, and we got an order from the Mumbai High Court to have a court-appointed receiver conduct raids on the premises of the defendants. And infringing products were found on the premises of 3 of the 5 defendants. And at the end of it, our client, having assessed the strength of its case, asked us to file an application before the Bombay High Court seeking mid-litigation mediation. And we were successful. The application was granted, and a single judge of the High Court directed parties to go to mediation at the mediation center which is associated with the Bombay High Court, which is something that Varun was talking about a little while ago. So the court has now sent us to mediation at the Mumbai High Court Mediation Center, and I actually don't believe we're going to continue with the litigation. We are going to close this over here because both parties have now understood where they stand in the matter, and it's just an efficient way to close the process.
John, just to add, it just came to my mind, India had one of the most important religious cases which was going on. That was the Ayodhya and Babri Masjid matter. The Supreme Court in 2019 referred that matter to mediation. That was the first time. It was a 3-panel Supreme Court retired judges. They set up a panel of mediators to resolve that issue. And that has one of the biggest cases in India. So what I'm trying to say is that the Supreme Court also indulged in such high-level constitutional matters which involve a lot of constitutional provisions. Even those were referred to mediation so that you can heal and peace out. So this just came to my mind. So that is actually, you see the seriousness of mediation process, which India is also taking and other countries are also pushing, due to which the act has been enacted today. So just wanted to add that.
Okay. Thank you, Chopra. And it actually reminds me of the fact that sort of an ongoing debate in arbitration right now is to what extent might the arbitral tribunal, depending on how they see things, tell the parties, parties, it's probably a good idea, or it might be a good idea if you go try to mediate this. And this is a bit of a debate. I would say the Germanic lawyers are actually very pro pushing the parties towards mediation if they think it's necessary. The Anglo-Saxon are a bit more reluctant, and I think other civil lawyers fall in between. But it's an ongoing debate right now. So people can comment on that, or the other question I really had was, in a mediation, how should counsel act as opposed to an arbitration or litigation? So I'll leave it open. Why don't you get started? But if you guys can comment on that.
I was going to say something. Yeah, I was going to add one more thing concerning the mediation in the process of litigation itself. We have something here very similar in the UAE. We call it the mediation by referral from the judge himself. That, as you said, that the arbitrator can refer the matter to or say to the parties, why don't we mediate this? The same thing we have it here, even by referral from the judge himself, like in some personal status matters, some family cases, that the judge might refer the matter to the mediation center in the court, or by a specific request from the parties to the judge that we need to refer this to the mediation center or mediator in the middle of the litigation itself. Yeah, that's in the UAE here.
I just have, sorry, go ahead. Jeremie, go ahead.
Yeah, just maybe one word about what you just mentioned. Obviously, this is excellent if arbitrators can refer to or suggest the parties to refer to the case to a mediator. I think the key point here is the interests of the arbitrators. And to speak very clearly, will they be paid entirely if there is a settlement agreement that is reached with a mediator or not? I think that's the question you need to answer before saying anything else.
I think it's an excellent question. I would actually say, as a professional, you should do what's best and let the chips fall where they may.
Yeah.
But but if you tell me I'm going to get $1 million if I go ahead with the arbitration and 10,000 if I move it to mediation.
Yeah. That's the point. I think.
Okay.
That's the point.
Chopra, go ahead.
The only thing I want to add to what Jeremie said was, in my experience, when the court directs parties to go to mediation mid-litigation, they actually stay the proceedings. But often in arbitration, when the arbitrators direct the parties to go to mid-litigation, mid-arbitration mediation, the arbitration actually continues. That's the one difference I've seen in my practice.
But then I have a question to that. See, if the parties are being referred to mediation, what will they proceed? And how will they proceed in the arbitration is the question that one has to ask. But nonetheless, that is one question which the lawyers have to debate in those facts and circumstances whenever they come. But now coming back to the acceptability of mediation, if you look at it from the point of view of international companies also, in India, mediation as a process, a pre-litigation mediation for international companies is also accepted, is also widely accepted now. And now just to add, I have a small question, John, for you. Is once the arbitral tribunal is set up and then appointment of a mediator by the tribunal, is just a change of hats by the arbitrator to a mediator?
I would say no. And actually, the arbitral tribunal would suggest to the parties, and I've actually not done this, but I understand this is how it would work. They would suggest to the parties that they try mediation. In that case, it would be up to the parties to go find their own mediator, and then it would be up to the arbitral tribunal to determine whether to stay or not the proceedings during the course of the mediation. I would say as an arbitrator, if it's going to be a 30 or 60-day mediation process, it would probably be best to stay the proceedings. But listen, we haven't had any questions from the audience, and I think there might be some, and I see that a hand is being raised back there.
I'll speak loudly.
Well, we'll get you a microphone.
Thank you very much for this informative session. I would like to ask about the general trends of mediation fees, to how to determine the mediator's fees and in comparison with the arbitrator's fees. So any overview, because actually, I mean, this is something always been discussing, and mediation is supposed to be not costly. So just want to have your thoughts. Thanks.
Yeah, thank you.
I gave the microphone to Jeremie so he can start.
Thank you, John. Thank you for the important question. My experience is that mediators are paid by the hour most of the time, and the hourly rates are comparable to those of partners of international law firms. So that's 700 to 1,000 euros per hour during the mediation, which is, in the end, is not so costly because that's only one person you're paying. But there are also a trend that is developing with some success fee for mediators. So you can have an agreement right at the beginning between the parties. If the mediator reaches an agreement, if there is an agreement that is reached between the parties, then the mediator will have a certain amount of money to in addition to the hourly fees. So that's not only, obviously, not pure success fee, but a mix between the two, and just to incentivize the mediator to be persistent in his efforts to reach an agreement between the parties.
My experience in Singapore has been that the mediation process costs a lot less. The mediators are well paid, but by simple dint of the fact that the mediation process is shorter, it becomes less expensive. I also like the way some of the arbitration rules out on the Southeast Asian side work, because SIAC, ICC, HKIAC have a schedule of costs. And the schedule and your arbitration costs become clear because it's a function of the value of your suit and the counterclaim. The LCIA is different. The LCIA has, as Jeremie said, an hourly fee for arbitrators. I just find mediation to be cheaper because the process ends quicker. You can have well-paid mediators, but because it's a shorter process, your costs are kept down. And counsel fees are lower as well.
Indian perspective, just to add to that, from the Indian perspective, the Arbitration Act, Conciliation Act has a scheduled fee for the arbitrators. For the mediators also, when you are a paneled mediator with a council, or which is a mediation center which is attached with the high courts, which is mandated by the Supreme Court, then there is a fee schedule which is capped. Say for 10 lakh rupees, it will be X amount. For 15 lakh rupees, it will be X amount. So there's a proper schedule which follows. However, like the Arbitration Act, it is between the parties to decide whether they want to give the same fee or the scheduled fee. So that can be changed. But the new Mediation Act is also going to come up with a specific schedule for the fee of the arbitrators. Oh, sorry, mediators.
Okay, we have a question. Can I add something? Yeah, go ahead. Does it work?
It works.
Yeah. So I believe from the UAE perspective, from practice, I think the mediation is much cheaper than the arbitration, because the arbitration process in the UAE, for example, if we consider the Dubai International Arbitration Center, DIAC, the fees for the arbitrators, for the arbitration would depend on how many arbitrators the parties choosing. And there is a calculation for fees in the website, which gives you a huge amount of fees comparison to the mediation. If we consider the mediation in Dubai courts or any other federal courts, would be much cheaper than the arbitration. Yeah, thank you.
Okay. Again, I don't know if you heard the gentleman, but what he said was in the Saudi Center for Commercial Arbitration, they do set a rate for mediation fees, which I think was 20% of the arbitration fees.
Yeah, 20%
for one arbitrator.
So if the 3, so 60%.
Unless the parties agree otherwise. But it's good that it's probably a reasonable sum, and it's...
Very interesting fee schedule. 20% of the arbitrator's fee.
Okay, we had a question back here. And then Zia.
Thank you very much for your informative discussion. Just to add a comment on the fees. Actually, in UAE, in particular, if the mediation referred by the court, the court dictates the fees for the mediator. If agreed, because here actually maybe you didn't touch on the mediation where there is no prior agreement or there is no referral through the court. So usually if the parties reach into a dispute and there is no clause for a mediation in the contract, so either the debtor or the claimant, respondent might appoint a mediator. A well-known mediator has a social reputation in the market where he can go and solve this amicably, and he can do it in caucus. He will not sit between the two parties, try to solve the problems, because this is usually used by the known people in the market. Culture, it's a culturally forced those people not to go to court or arbitration because of their name in the market. So usually they go for mediation, and it is done in caucus. It's not done otherwise. Lawyers will enter.
What do you mean by in caucus?
In caucus, that means I sit with the claimant separately, and I sit with the other party separately, and they don't know each other. So I try to solve the problem between them without any lawyers in between, because lawyers usually spoil the mediation. Sorry, and for the lawyers, they spoil, to be frank with you, because they need to go for litigation or arbitration because they need more fees. So that's natural. So, but these three types of mediation are available in the market. Two are known to everyone, but this one, actually, they usually select a well-known person to mediate and close the case, because these people, well-known in the market, they don't need their names to appear in the courts or in arbitration. Thank you very much.
Thank you very much. And again, what he was talking about, there are various ways of handling a mediation. You do it by caucus, you do it everybody together, and it depends a lot on the Actually, let's go to Ziad first, because he had his hand up, and then we go over here.
Thank you. Thanks, guys. Very informative. I'm going to pick your brain on something. So I don't know if you follow the VIS moot, and I think the mediation item is quite topical. It's one of the issues in the current moot problem.
I haven't read the problem yet, but
right. Okay. Well, one of the issues is whether or not the party is able to start the arbitration process without having first completed the mediation. So and that goes back to the drafting of the contract. And different jurisprudence, different countries will have different views on whether you can skip the mediation or not. But in practice, right? In practice, I've had, I don't know, 10 mediations in the last 20 years or so, non-court related through the Abu Dhabi courts. I've only had one successful mediation, and then the party reneged right afterwards. So the mediation went well until everything went sideways after that. At the courts, I've had, in recent memory, I've only had one successful mediation, and we weren't able to complete the process at court because the court mediators would say, it's not my prerogative to sign on transfer of shares, go do that through the notary and through whatever. It was like, yes, but that's the agreement of the parties. Please, can we just finalize this? We couldn't get it done through the courts. So, it's the realities, or maybe we're just very lucky and we get all the crazy cases, right, that don't work. But it had me questioning oftentimes, what's the value of putting those into the contract? I mean, if the parties are genuinely interested in solving the problem, you can sit down, and we did do this in one instance. Contract did not provide for mediation, and the parties were interested in solving the problem. We said, let's do a mediation. So they did an ICC mediation. It didn't work, but they tried, right? They weren't able to get to see eye to eye. But there was a genuine will to solve the problem. Most of the time, I don't see that will from either one or the other side. Either the claimant has got, they just want to make it all the way through, regardless of the consequences, or the other side just wants to play hard and just be sticks in the mud, like you mentioned, right? So
as a mediator, I have seen that, and there are times when it's done because it's a formality in the agreement and they have to do it, and you see one side has no interest whatsoever in resolving it. And I think that goes back to what Jeremie said earlier about why companies are somewhat divided about the efficacy of mediation. Some have had experiences like you, and they say, why bother?
I think I also have a comment. I agree with John 100%, but I see that putting the mediation clause in the agreement is actually it's a formal method to give you a guilt-free pass to file the case in court. So we are putting this on paper that we've tried, but nothing happened. So I'm free now to file the case. So this is from a litigator perspective.
Yeah, but it doesn't carry any weight, though. There's no stick behind it.
We had another question over here.
Sorry, John. I have a couple of things on this. I've seen some successful mediations at the SIMC in Singapore, and those have worked out pretty well. There are two benefits, I believe, in putting a mediation clause in. One is it gives parties a little bit of time to cool off. Because when the dispute first arises, there's a lot of angst and bad feelings. And to sit and to be able to talk it over, you may not reach a successful mediation. It allows parties to cool off and proceed accordingly. The second thing is, I believe a skilled mediator can sometimes demonstrate to a party that their case isn't as strong as they maybe think it is. Okay? And therefore, it may not make sense to proceed. I'll just end with this. I haven't seen a huge percentage of mediations ending successfully, but I've seen some good ones in Singapore which have worked through the SIMC. And when it does, the benefit is disproportionate. Because a dispute and an arbitration isn't like a transaction, right? At the end of the transaction, everyone kind of wins. But at the end of a Singapore arbitration, somebody's lost, and you've also ended up paying costs on the other side. Powerful incentive to get the mediation to work. That's just it.
Thank you so much. I think in practice, on a reality, the issue of mediations is not very favorable by the parties, because if you see that, if you look at agreement, free agreement between the parties sometimes started by amicably, if they dispute, amicably resolve dispute or cancellation. And for that, after that, if they give time for their cancellations, if not, they will go for arbitration. But if you know that, give time for, because mediation is depend or rely on skills of the mediator. Can he mediate between the parties? For example, for construction contracts, can mediate for the parties and to succeed to persuade them for his points and to mediate and to reach settlement or to reach decisions or not. Even now, mediator can work by his skill and to persuade for settlements or he cannot, if he make as a mediator, if I'm a part of contracts, if the mediator, if I didn't agree with mediator, with his point, with his decision, this is my point, because I am when I made my contract, I have seen that if any breach of contract, we can go for settlement or for arbitration. But for mediation, if the mediation make an award, it's difficult for enforcement within the court. But for arbitration, I think arbitration is benefit than mediation, because arbitrations, these point of arbitrators see that is what is happened, and then they made an award. Award, they can implement it through judicial or legal systems, or the court systems. But for mediators decisions is it's maybe implemented, but it's difficult, because for me as I'm looking at you, not you are sitting as a mediator. For me as a party, you are a mediator. If you persuade me by your points, it's okay. If not okay, I cannot accept what you cannot decide for me that as a mediator. But for arbitrators, it's better. For arbitrators, I think arbitrators, but this is in practice. That is what I say. Now, in practice, some people, for many contracts, specifically in construction contracts, saying that if dispute arises between the parties, they start by cancellations. They give some time for 60 days, 90 days for cancellation. If did not reach compromise or settlement, they should go to anyone can enhance and can start arbitration by himself. That is why this is not my opinion. I don't know what you agree with me or not.
We'll give some comments now. Jeremie?
Yeah. Thank you for these comments. And Ziad and I have also a lot to say about this. I'm more enthusiastic about mediation. I've got statistics that prove that it can be efficient. But there are key factors of success. And one is the timing. And clearly you need to engage into mediation either at a point where the conflict is not crystallized, so you still can manage the parties to reach to an agreement, or at a later point when all parties have been able to demonstrate their points and they have a clear view about their strengths and weaknesses of their own case and the other party's case. That's the two timing where it's good to mediate. So now to answer your question, sir, or your two comments, a mediator is not here to make a decision in place of the parties. He's here to help the parties reach an agreement. But the agreement will be signed by both parties voluntarily. And the effect of that is that it will be enforced voluntarily by the parties, much more than arbitration awards. So there is very, very little. That's one of the big advantages of mediation, because the parties are willing to reach an agreement to settle the case. So they will voluntarily execute the agreement. As opposed to awards by arbitral tribunal, where you know that sometimes it's difficult to enforce, and that's another litigation following the arbitration. But I've got many other, best practices to share about ways and experience about ways to make mediation a success. There is the timing, there is type of mediator, how you select the mediator. I would like to emphasize something that is rarely discussed, is the job of the external counsels of the parties. It has been said previously that external counsels can be a pain in reaching an agreement, because their interest would not be to settle the case, but to go to court or tribunal, etc. I think that you need to have counsels that are trained, experience into mediation, because they need to change the mindset as soon as they start the mediation to cool down the pressure. It can be very tense, but you act differently if you are at court, being sometimes very aggressive with the counterparty, and when you're around the table with a mediation. So you need to completely change the mindset, and you also need to work on the interests of all the parties involved in the mediation. So as an external counsel, I always work obviously with my client, because he will do the talking during the mediation most of the time. So I will brief him, we will discuss the strengths and weaknesses, what are the other alternative routes if there is no success in the mediation. So all this is normal, should be the normal work of a counsel during the mediation. But what you can do also is to work on the interest of the other parties, so what they expect from the mediation, strengths and weaknesses, that you will be able to tell them in the eyes around the table, which you cannot do if you're before court or arbitral tribunal. But you also need to work on the interests, specific interests of the counsel of the other party. I've got a case, maybe very quickly to share, where the case started because of the badly drafted clause of an agreement for the purchase of shares. And the counsel of the other party was the one for the dispute, were the same, that's the one who drafted the clause, which is the sources of the dispute. So obviously he had a conflict of interest in resolving the dispute. So I had to manage this apart from all the other interests. And the last one is obviously the interest of the mediator himself. So you need to be to build a relationship with the mediator, so he rely on you as being a trustful person, and also you can help the mediator. For instance, when you by giving him information, by asking for a stay in the hearing of the mediation to get some relief or ease the tensions, etc. So you can be very active, But you need to bear in mind that your role as a counsel is very different in a mediation compared to usual arbitration or dispute litigation.
Thanks, Jeremie. Chopra?
Just to add, I'll just make 3 quick points. Point number 1 is with regard to the mediated settlement agreements in our jurisdiction in India. Under the 2023 Act, Section 27 mandates that they can be enforced as an arbitral award or any other award. They are binding, final, and enforceable. That is point number 1. Point number 2 is with regard to the settlement agreement. I have seen this in past, and it's my personal experience in a matter which I read yesterday also. There was a settlement agreement between the parties in ICC. Now that settlement agreement subsequently was eclipsed as an award and thereafter enforced in India. So in that I raised the specific argument that it is a settlement agreement, and in India Part 2 does not recognize a settlement agreement or an award which is settled. It has to arise out of disputes. So we raised that arguments, and that matter is still pending. Any which ways, and the last point is, point number 3 is, whenever you draft any clause, get a good lawyer amongst us. So that's very important.
That's the most important. Go ahead.
Yeah, I would like to add one more thing very important as well, beside the well-drafted the dispute resolution clause. That in international commercial transactions, in the contract itself, as a lawyer, you have to advise your clients about the jurisdiction, whether the jurisdiction, the mediation there would help your interest or no. So this is very important before choosing the mediation, because sometimes they put mediation, and mediation in this jurisdiction is not efficient. And then at that time, your client will lose. You will lose time, and sometimes if you skipped the mediation, the state court will consider the case is immature or not ready to be heard yet. So I think it's...
What for you? Like in mediation, my friend said that in mediation you need to choose the seat or the place or jurisdiction. So that question at a later stage will also evolve. What is the seat of mediation or place of mediation? That will be a good question which everybody will have to ask, and probably in future judgments which will come, and that will probably settle the law. Right now it's too nascent in order to even go into there. Because our act is very nascent. There is no question of place or seat or jurisdiction unless and until there are councils.
Yeah.
Sorry, just one last thing. A couple of successful mediations, and the way it's worked out is at the end of the mediation, the parties enter into an agreement, sort of reflecting the terms of the successful mediation. Take that settlement agreement, file it with your arbitrator or by your court, and the panel will pass an award in accordance to the settlement agreement, and that's it. So you don't need to have a separate enforcement mechanism for the mediation award. You just file a settlement agreement in terms of the award, and both your court and your tribunal will enforce it.
One thing I will say as a mediator, and it's sort of at the end of the mediation, when you've got it done, its parties seem to be in agreement. The hard part then, and it actually takes a lot of additional time and some effort, is making sure that the parties actually draft the settlement agreement. And I urge the parties to come to a mediation with draft settlement agreements so they have a document to work with. And then it can take an extra day or couple days, but if you work with the parties to make sure that they actually complete the agreement, it gets it done. Because if they go away and say, okay, we've got points of agreement and we'll fix this up over the next couple of weeks, there's a good chance it won't happen. Listen, I'm going to ask my panel members if they have anything else they want to say that they have been thinking about that we've missed, or if there are any final questions from the audience. Anything else?
Yeah. Get a good lawyer.
Okay. Thank you, everyone. You've been a great audience, and we had a lot of fun doing this.
Thanks a lot.
Thanks very much.
Thank you.
Thank you, panelists. Now I'll request Mr. John Lowe to please present the mementos to our panelists.
Thank you. It was a pleasure. Thank you. Jeremie. Thank you, Jeremie. It was a lot of pleasure. Thank you very much. Thanks a lot of fun.
Thank you. I had fun.
So let's have a group photo.
Don't you stand and sit there.
Okay. No plaque for you. Well, you've gotten too many plaques.
The baggage.